Good morning, I am Charles Musgrove with the Bean Team and host of Business Matters. Welcome back for another exciting show. You know, we bring knowledge and nuggets of knowledge to the viewing audience. We help businesses take care of the issues to run their business better. So we have a lot of shows that we've already recorded. They're out there on Apple Podcast. We also are heard every week on Real Talk 93.3 out of Tallahassee, Florida. And we're on 30A TV out of Destin, Florida. So check us out on YouTube. You can see that wherever you are. So take a listen on Apple Podcasts. Watch us on YouTube. And today is no exception. We have some powerful information that we're bringing to you today. Megan, welcome to the show. We've got Megan Jones.
Hi, Charles. Thanks for inviting me to be here today.
Megan is an expert attorney, and she specializes in the human resources, the employment law, contract law. And tell us a little bit about the law firm that you work with and your specialty.
Sure. So I'm employed with Hall, Gilligan, Robertson, Shanlever. We have 4 offices: Atlanta, Savannah, Georgia, and then one in Destin and one in Seagrove Beach, right off of 30A. So we have been a law firm since 2011, established, and we just moved down to the Panhandle a couple of years ago and established our Destin office as the most recent office just this past June. So we are growing and expanding. We currently have 14 lawyers that work with our offices, and we specialize in labor and employment.
Well, good. I'm excited that you're on the show with us today, and today we're going to talk about a subject matter that I think is it's new in the state of Florida. It's something that's headline material, and it's legalized marijuana. And you know, that's a personal prescription medical issue that people have to deal with, but it also seeps into the employer and the employee relationship. So that's really what we're going to focus on today on our Business Matter episode, is how does that affect the employer and employee relationship, because it's just got implications that are vast.
It does, and especially in the Destin and Seagrove Beach office, where a lot of the industry is geared towards tourism. So you have a lot of restaurants, a lot of lodging, and a lot of construction business owners here, and that's kind of where the industry is going in the Panhandle. A lot of your employees are laborers and part of the labor force that may or may not use legal marijuana or non-legal marijuana, and that can become an issue when it seeps into your labor force, and then you're trying to comply with Florida's work-free drug place, and you're trying to maintain a labor force that's reliable, that you can make sure that will be on time to certain jobs, waitressing jobs, cleaning rooms.
The labor force, I think, in any location is a challenge now for the employers, is to get reliable employees to fill the position. So in the hospitality industry, like in this area in Destin, is especially a challenge, is to get reliable employees. So I see so many issues with because there's just the backdrop of that is, for federal purposes, there is no legal use of marijuana. It's still illegal as far as the federal laws are concerned. So you have a conflict in these state laws and federal laws, so that creates an issue. Is that right?
That's right. So it's still a controlled substance as far as the federal law is concerned. And then in the state of Florida, we have a legal marijuana statute that allows people to obtain medical marijuana licenses for a limited purpose. And it limits the people who qualify to obtain that license. It limits the people who are able to sell medical marijuana, so the businesses that are allowed to engage in the sale of that. And then finally, your growing industry. So the state of Florida has maintained oversight in all of the 3 big areas of monitoring this legal marijuana and medical marijuana issuance within the state of Florida.
So now it is legal. There's monitoring, there's controls over who grows it, who sells it, and how you legally obtain it. So let's say that the individual, the employee, legally obtains the medical marijuana, and now they are in an employee relationship with an employer. So
sure.
What barriers are presented now for that employee to be hired by an employer? So that's kind of step one. How do you get is it more difficult for that employee or that supposed employee, prospective employee, to get hired?
Yes, it absolutely is. So Florida has determined that they are not going to require employers to supersede or to violate the federal law if that employer chooses not to. So in order to protect the employer's right to choose, Florida has allowed employers to institute a drug-free workplace policy. And what that means is that you can have a policy in place that tells employees, both prospective and current, that you are maintaining a drug-free workplace. And so long as you are maintaining a drug-free workplace, that they must complete a drug screen before they are permitted to work. So your job offer must be conditioned on a clear drug screen is the first thing to comply with Florida's drug-free workplace policy. And then employers are required to test whenever they have a reasonable suspicion that an employee could be under the influence or using illegal narcotics. And so that places a burden and responsibility on the employers. Now, the benefit to the employer in maintaining that drug-free workplace policy is that if there is an employee who fails a drug screen for THC, which is the active ingredient in medical marijuana, then they can terminate that employee on the spot, and that employee cannot sue them for any discrimination reasons as it relates to that marijuana.
All right. So now there's if the employer chooses to be drug-free,
yes,
then there's a pre-hiring test that's done.
That's right.
So let's just throw this down in practical terms. If it is an employer that they're desperate for employees and they look the other way for those during the hiring process, and they don't do a pre-hiring screening for medical marijuana or other drugs.
Sure.
So those people that are legally using marijuana, they're hired. So is there an out? Are the insurance companies, say workers' comp, are they standing in the breach and saying, okay, there was not a pre-test, so the employee that is using medical marijuana is working, they get injured, then there's always a post-accident test and they find out that they're using legal marijuana. So then what happens? Does the workers' comp company then say, we're not going to cover that? Or can the employer at that point take action for that not to be covered, or what happens then?
So in that situation, the employer, by not testing and pre-screening, they have waived the protection of having a drug-free workplace policy.
Okay.
It's as if it never existed. So in that situation, the insurance company is absolutely protected by the workers' compensation. So if someone is injured on the job and tests positive for THC, then the insurance company is not required to pay for that person's THC or prescription following the injury. So they are protected by the statute.
Okay, so that's only paying for the medical marijuana. How about
Right.
the injury itself?
So the injury itself, if the employer had a reasonable suspicion and turned the other way, then the employer can be responsible for that injury, even if the insurance company denies coverage.
All right, so that's a major issue that the employers need to be aware of. So
yes,
the insurance company, the workers' comp carriers, they have an out.
They have an out.
Because why do they have an out? I mean, is there something written in the statutes that say workers' comp carriers, you don't have to cover this accident because they were using medical marijuana?
So the burden's on the employer to be able to prove that the accident occurred because of the use of marijuana, and then the action would not have occurred but for the use of the marijuana.
Mm-hmm.
If the employer cannot establish that, then it's not proven whether or not marijuana was at issue. And if they don't have an enforceable drug-free workplace policy, then they're on the hook for the workers' compensation claim that may be coming in the future.
So they would, if they knew that it was either the workers' comp carrier covers it or they covered out of pocket, they're not going to want to prove that it was a workers' comp or a medical marijuana caused injury. They'll want the carrier to cover that.
Right.
Okay.
Right. So as an employer, you want to make sure that you have that drug-free work policy in place, and that you protect yourself to make sure that everything is covered by the insurance policy. And the insurance company will also investigate this. So they'll determine if the employee's actions were caused by marijuana, what the test results mean. And if they determine that they're going to send you a declining of the rights letter or reservation of rights letters, kind of the terminology, where they're not going to protect you, well, now not only are you facing a lawsuit as the employer by the employee with no insurance protection, but if that insurance company should not have denied the claim, now you as the employer have to sue the insurance company under a breach of contract claim to show that they improperly denied the claim. And obviously, for small business owners, this just means dollar signs, because that means a lot of legal entanglement.
Absolutely. So you could have the situation where that employee was driving a car,
right,
which was covered normally. If they caused injury to someone else, then there may not be coverage for that, because the insurance carrier may look into that, investigate it, and say this accident was caused because they were
under the influence.
Right.
Just the same as if it was that they were under the influence of alcohol. So an insurance company will evaluate that and determine if they're violating the law, then they're not going to cover it. And
okay. Is that different if they were on an opioid?
It is.
Okay.
So as long as the employee maintains a legally valid prescription for hydrocodone, Oxycontin, Percocet, things of that nature, and they take it in the way it is prescribed, then the employer has to consider the Americans with Disabilities Act, which states that they cannot terminate that employee for that reason.
Okay, so there's protections provided for the use of oxycodone and all the other opioids. Right. There's not for legalized marijuana, even though legalized marijuana may be a healthier, I'm a non-medical person, but a healthier solution for that person's ailment. Right.
It may not be as detrimental to the employee's lifestyle to take medical marijuana as opposed to some of these opioids. And right. So much of the nation's headlines are geared about these opiates and how they're impacting everybody. But currently, medical marijuana, because it's still a scheduled substance, a controlled substance in the federal law, states do not have to adhere to nor comply with.
So we may see these laws changing more in the future, because it's all, just with the disparity of Florida law versus federal law, you can see that those are going to eventually kind of merge together.
It will absolutely merge together. Currently, the ADA is a federal law, which is why you can terminate someone for using medical marijuana. You cannot terminate anybody for using Percocet or Ambien or some of these other prescription narcotics, as long as they are properly prescribed.
What is I know with the use of alcohol, there's standardized tests to determine if you're over the limit. Usually that relates to driving under the influence. What's the testing like right now for marijuana causing you to be under the influence, if that's what it's called?
So it's virtually non-existent, which is a problem right now for the entire country and the states in general in determining how they will be able to test people immediately on the roadside and determine that they are currently under the influence of a narcotic. Europe has a test that they have been using, and it seems to work and has been adopted by the courts as being, something that's reliable, and that is to do a saliva swab. But there's no state in the United States thus far that has incorporated that within their state law, that they are now going to accept this test to determine if someone is actually under the influence of a lot of these narcotics.
Interesting. The headlines you usually read is the police stopped someone driving the car and they smelt cannabis, and they then investigated, looked at the car, they did whatever the next step was. But I don't know that I've read yet that they tested to there's no measurement that they test by that says, okay, they were over the limit.
Right. So what's happening right now is that marijuana stays in someone's system even if they're not currently under the influence. It will test positive for, I believe, up to 30 days. And so because of that lingering effect in the testing, it's very difficult for especially employers to prove that an employee is currently under the influence. The way that you can test that is by doing a blood test. And so law enforcement will do that if they pull somebody over and they believe that person's under the influence of narcotics. They can then take that person to a hospital, run a blood screen, and determine that the person...
So that sounds like that's more time-consuming and costly to do that.
And employers don't have the right to do that.
Yeah, interesting. Before we move off of this topic, we talked about drug-free workplace and when a prospective employee is hired. So one of the documents or the forms that's often used is the employee handbook. So
right.
Talk a little bit about the importance of keeping that employee handbook updated and making sure that you get that change for the laws that are changing. And this is a perfect example of medical marijuana. Have people adjusted their handbook for that?
They have to. They have no choice because employers don't realize, or some employers don't realize, that if they don't update to take into consideration this law, then they're waiving the protections that are under it that they are entitled to. So it's critical that they update their employee handbook. And in fact, our office, we have a separate drug-free workplace policy. That's a separate form that the employee has to sign. It generally says something along the lines of they understand that as a condition of their employment, they have to pass a drug screen, and then the employer maintains the right to randomly test that employee should they determine to do so without any reason at all, or if they have a reasonable suspicion that that employee is under the influence. And that way that protects the employer, and they have a separate document from their employee handbook that shows that the employee acknowledged.
They've acknowledged it.
That's right.
What are there any new case law, any new anything out there where this stuff has gone to trial and there's been judgments, that anything new in the court system? So
not as far as Florida is concerned. It seems like currently the Court of Appeals are getting some cases that are kind of snaking up to them, but the problem is so many of these discrimination cases and things like workers' compensation cases have to go through the administrative courts first, which is a long process. And then following that, if you get an appealable order, then you can file it with the First District Court of Appeals for us here in the Panhandle. And then you have to wait for the Court of Appeals to docket it, for them to brief it, and then for the attorneys to brief it, and then for the court to either hear oral argument and make a determination. And so because that's such a long process and this law is so new, there hasn't been any new developments as of yet, which is why we're still having this debate about how this is going to impact employers and employees in the long run.
So this was legalization of marijuana. That was that's been passed for how long now? 2 years?
2 years, 2017.
2017.
Yes.
Okay, so that is so what's new, since we're about to go into session now in January? So what's new on the docket as far as possible changes, expansion? Because that's what we're seeing in a lot of places is it starts out medical, then it goes to recreational.
That's right.
So we started out medical, and there's been some expansion in that area as far as new growers, new dispensaries. So what's going to happen next? So
the legislature right now in the state of Florida has been trying to get as much science and scientific knowledge as they can about the benefits of medical marijuana and compare those with opioids and determine, whether or not it is in fact better for the general population. And because of that, we have a lot of non-government organizations that try to push through on ballots new law if the legislature, they determine it's moving a little slow for them. So as recent as yesterday, this Sensible Florida Incorporated company was trying to get enough signatures to be able to place recreational marijuana on the ballot in the state of Florida for November 2020. So during the presidential election, we would also be able to vote on whether or not recreational marijuana could be passed in the state of Florida. And the requirements were that they receive 766,200 signatures And yesterday they suspended their campaign because they had gathered 92,540. So they were, a little bit more than $500,000 low. So
how they ever came up with that, the signature requirement is beyond me. But the number that for any ballot initiative, they have to have 766,000 qualified signatures for that. So they were way short of that requirement. So that's most likely why they pulled that. But this may be, I don't know if this is the first, but it's one of the early initiatives for complete recreational use of marijuana, an initiative. So that failed. So
that failed, and that was, a non-government organization trying to put that on the ballot, kind of taking over the job of the legislature to enact a recreational marijuana statute under Florida law. So what is happening right now on the legislative side of things is that there are currently 5 bills that have been introduced. So the legislatures, the House and the Senate, meet during the months of October, November, and early December in committees. And so each member serves on a committee, and as part of that committee, they can introduce things that are of interest to their constituents. And so that ended, the committee period ended December 13th. So that just ended 4 days ago, last week, right. And so Senate Bill 760 has been introduced. And what this bill will do is it will ban all smoking and vaping in state parks and on state-run beaches. And that's important to note that will affect, obviously, medical marijuana and the consumption of medical marijuana if you have a vape, if you use it by vaporizing, or if you use it in a smoking matter.
So that's one that restricted.
That's restricted.
Are there some possible changes that's going to expand the use of
there are
medical marijuana?
House Bill 339 will allow judges to change the minimum sentencing requirement, so that way they can reduce even beyond what the current statute allows for sentencing for violators who are in possession of marijuana. House Bill 149 defines treatment centers and growers, and actually proposed to expand persons, businesses that were allowed to either grow marijuana for the sale of medical purposes, and then the actual storefronts that were able to engage in the sale of the medical marijuana. So those would potentially be expanded from that. And then Senate Bill 212 will actually allow more businesses to sell not only medical marijuana in the smoking format, but also edible cannabis. So it's kind of expanding in what ways you consume the medical marijuana.
Interesting. So this has been, we could go on and talk about medical marijuana and the effects on employees and employers in the workplace for probably 2 or 3 more shows. So this kind of whets the appetite of what's out there to expose business owners, those that manage businesses. So this is another issue that really takes attention, and it takes the business owner to pay attention to this issue, because it's real. It's here on us now, and it's something that can be detrimental to your business if you don't pay attention to it. So Megan, thank you so much for joining us. This has been a lot of knowledge nuggets that you brought to us today, and thanks for joining us. Check us out next week. We do one of these shows on a weekly basis. So thank you for joining us on Business Matters. I'm Charles Musgrove, your host, and check us out on beanteam.com. You can see all the past shows, or Apple Podcast, or YouTube. We're out there. Check us out. Have a great day.
And a Merry Christmas.
Yes.
The Business Matters Talk Show with Charles Musgrove is sponsored by the Bean Team. For all your business accounting and tax preparation needs, visit beanteam.com or call 893-7710. You can listen to more episodes of Business Matters on Apple Podcast, YouTube, or visit beanteam.com.